Good morning, everyone. We're going to give everybody just a few minutes to join us this morning, and then we will get started here probably in a couple minutes. So thanks for being with us this morning. We'll get started here shortly. Good morning, everyone. If you just joined us, we are just giving some of our participants a minute or two to join, and then we will get started. So thank you for being with us this morning. We're just going to give everyone a few more minutes to log on. All right, I think we're going to go ahead and jump right into this morning. Good morning, everyone. Thank you for being with us today. My name is Emily Mack. I am a partner in the Nashville office of Burr and Foreman. My practice concentrates on labor and employment law, and I am joined today by my colleague, Diamond Stewart, who is also in our Nashville office, and we are excited to be speaking with you this morning on something that doesn't involve COVID, quite frankly. We are going to be talking to you this morning about where we're at right now with sexual orientation and gender identity in the workplace, what we need to be thinking about as employers, and how what some best practices are going to be for dealing and navigating with these issues as we return to the workplace and things of that nature. This, of course, follows on the heels of the U.S. Supreme Court's decision that was issued last June in Bostock versus Clayton County. And that was the decision that explicitly held that, that sexual orientation and gender identity are in fact protected under Title VII, and specifically Title VII's prohibition on discrimination on the basis of sex. So we are going to be looking at that decision today. We are going to be looking at kind of what led up to it. And then we are going to be talking about what has happened in the year and a half that has passed since that decision was issued, because we now have some more court decisions and agency regulations that have come out in light of Bostock. And then we're going to jump into kind of some best practices for employers as you begin, struggle to maintain compliance and kind of update policies and procedures and look at what needs to change in light of this opinion for those of you that it applies to. So I think we're just going to go ahead and jump right into this. Diamond, do you want to talk a little bit about the legal landscape before we got this decision last June from the United States Supreme Court?
Yes. So good morning, everyone. As Emily said, I'm Diamond. I'm in the Nashville office and I'm a staff attorney here. So before we even just start our discussion, I think it'll be helpful to kind of lay out Title VII of the Civil Rights Act of 1964, because this is where a lot of our discussion today stems from. And that states that it shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's sex. So when we're talking about gender identity and sexual orientation today, sex is really that protected characteristic that stems all of our discussion today. So it's important to kind of lay out Title VII so you can see that sex is one of the classes that's protected, but sex today, we're going to be talking about sexual orientation and gender identity. And just a little background, gender identity actually is a person's internal sense of being male or female, non-binary. And then we have sexual orientation, which is a person's identity in relation to who they are attracted to. So I just wanted to kind of give those two definitions because we're going to be using those terms a lot today. So before the Supreme Court issued its opinion in Bostock, courts were really split on whether sex included sexual orientation and gender identity, or whether it referred to one's biological or reproductive organs that they were born with. So one case in particular that we'll kind of flesh through a little bit is Price Waterhouse. And before the Supreme Court issued its decision in this case, lower courts really understood that sex under Title VII referred to one's biological sex and reproductive organs, and claims that were brought by homosexual and transgender individuals are actually uniformly shut down. So in the Price Waterhouse case, we had a female employee who applied for partnership in 1982. Of the 662 partners at the firm at that time, 7 were women. And of the 88 individuals up for partnership, Hopkins actually was the only woman who was even being considered for partnership. Price Waterhouse had a method for voting in place where basically partners in the firm would give their opinions. And a lot of the opinions about Miss Hopkins were she was macho, impatient, difficult to work with. And the manager even actually told her that she was denied partnership because she should walk, talk, dress more femininely, wear makeup, have her hair styled, and wear jewelry. So she really was denied partnership for all of these because she didn't live up to that employer's gender stereotypes of how a woman should act, talk, behave, walk. And so the Supreme Court in 1989 actually held that that Title VII wasn't limited to biological sex, and it also included these gender stereotypes. Emily, do you want to kind of talk about how the lower courts were kind of split on this decision?
Right. Yeah. And for me, it's hard to believe. Price Waterhouse again said, that gender expression is something that is a protected characteristic and falls under Title VII's prohibition on on discrimination based on sex. That you cannot, like in Ms. Hopkins' case, treat a woman differently for not acting femininely enough. And so when you extrapolate that decision and that holding, it seems like it would have been pretty well established after that decision that sexual orientation and transgender individuals do have claims under Title VII when they are discriminated for not acting in accordance with gender norms. That's what you're saying. If you're firing someone because they are male and they are attracted to males, but you would not fire someone if they are a male and they are attracted to a female, that is, they're not conforming to the gender stereotype, and you're taking action against them based on that ground. And so, it seems like it should have been settled, but it wasn't. And I think this is one of those, unfortunately, where the court was a little bit ahead of probably societal norms and cultural opinions. And so what we had is a lower courts that would continue to kind of say, well, Price Waterhouse really didn't talk about sexual orientation. It didn't involve someone who was a transgender employee. And so they kind of ignored that holding and instead, would impose classifications such as homosexual or transsexual on a plaintiff, and then legitimize the discrimination based on gender nonconformity, by formalizing that nonconformity into something that was an ostensibly, unprotected class. It wasn't based on sex. It was because of this individual's unprotected mode of self-identification, right? And so that's what you saw lower courts doing. And so it wasn't until 2021 where we had, or 2020 rather, where this issue came before the court again. And so we saw develop in the meantime was a circuit split where, you know, in the Sixth Circuit, Second Circuit, Ninth Circuit, sexual orientation, transgender were protected under Title VII. And those courts of appeals said that Title VII's prohibition on discrimination based on sex clearly includes these categories.
Right.
On the other hand, we had, you know, the First Circuit, Fifth Circuit, 10th Circuit, you know, that said these things aren't protected. They do not fall within discrimination on the basis of sex. And so this made this issue very ripe for the Supreme Court to finally take up and address. And, you know, one thing I want to, note here too, is that, when we get to this opinion and when we get to Bostock, again, we're talking about Title VII. So this applies to employers who have more than 15 employees. We're going to talk a little bit later about how this impacts smaller employers, you know, those that aren't subject to Title VII. Does it impact them at all? But when we're talking about this ruling in Title VII, that's who's subject to Title VII, is anyone with 15 or more employees. So Diamond, now that we've kind of set that landscape, do you want to talk a little bit about the holding in the Bostock decision?
Yeah, definitely. So really, the Supreme Court granted cert in 3 cases and issued 1 opinion. So I'll kind of just flesh out the 3 cases, just the beginning, and then I'll show you how Bostock got to the decision where we were. So really, the first one was in the 11th Circuit, and that was Bostock v. Clayton County. And this involved a public employee who was terminated. He was a good employee, exemplary employee, had great performance reviews, and he was actually ended up being terminated when his employer found out that he joined a gay softball league. And the 11th Circuit held that Title VII did not apply to sexual orientation discrimination. So that's the first one. So in the second one, which was in the Second Circuit, we had Altitude Express v. Zarda. And Zarda was a skydiving instructor, and he actually told one of his customers that he was gay just so she would feel comfortable, like, you know, skydiving in tandem with him. The customer's boyfriend was actually upset about this and told the employer that he was gay, and the employer ended up firing Zarda. So this case was actually the exact opposite holding as the 11th Circuit case in Bostock. And this one said that basically Title VII extends to sexual orientation claims, and reason that sexual orientation-based discrimination is a subset of sex discrimination. So we really see the exact opposite coming out of that case. Then finally, in the Sixth Circuit, we had G&GR Harris Funeral Homes v. EEOC. In the Sixth Circuit, if you're in Tennessee, we actually fall under the Sixth Circuit, just a side note. But Amy Stevens was a longtime employee of a funeral home, and she actually told her employer that she was going to be transitioning from male to female, and then she was terminated. The Sixth Circuit held that Title VII prohibited discrimination based on gender identity in that case. So in Bostock, the Supreme Court, like I said, really issued 1 opinion out of all 3 of these cases. And they said that Title VII's protections from discrimination on the basis of sex include sexual orientation and gender identity. So an employer who fires an employee for being gay or transgender really is firing someone and violating Title VII, because you're violating them and you're discriminating them on the basis of sex when it's based on sexual orientation or gender identity. It's also really interesting to note that the court actually had a but-for causation standard, which is kind of a legal term, but I'll explain it. So the court was saying that it doesn't matter if other factors besides the individual's sex contributed to the decision to terminate them or fire them. It really means that but for the individual's sex, that you would have been discriminating against them and liability can attach. So really the main opinion we got from this was that if you fire someone for being homosexual or transgender, you're firing them for traits or actions that you really wouldn't fire another employee for, or you wouldn't have questioned this in members who are of a different sex. So really we just saw that another point that the Supreme Court made in this decision was it doesn't matter if you're firing all the gay men and all the lesbian women, but it just means that you're discriminating on the basis of sex. So it doesn't matter that you're discriminating just against one class. If that makes sense.
Right. I think what they said is someone who decides to do that doesn't eliminate their liability; they double their liability, right?
Right.
I think that the terms that the court used, it really was kind of there were a lot of opinions that came out when we were anticipating that decision about how the court was going to rule. And it really, the opinion itself is fairly straightforward and really just based on statutory interpretation. There were a lot of arguments made about whether or not sex just means reproductive organs, or whether sex is, that term has evolved. And the court said, we don't need to, we'll acknowledge that at the time that the statute was written, it referred to reproductive organs. But that's not where the analysis ends, it's where the analysis starts. And the reason for that is that, what Title VII says about sex, and the fact that we cannot, that employers are prohibited from taking certain actions because of sex. The ordinary meaning of that is by reason of, on account of. I also like the practical scenarios that the court gave here to kind of illustrate this but-for causation standard, which is something, that applies in all Title VII cases. It's not necessarily something that is new, but it's something that the court used to reach its holding here, which is, if you fire someone who's female, the first scenario is that if you fire someone who's female because she's married to a woman, but you would not do the same to a man who is married to a woman, you're taking an action because of sex. And similarly, the second scenario is that if you fire someone who identified at birth as male, who uses feminine pronouns and identifies as female, you're taking an action because of sex, because you would not have taken the action but for the fact that the employee originally identified as male. In other words, there's no way to, you can't fully define sexual orientation or transgender status without identifying the biological sex. And then for instance, in sexual orientation, that is a function of the sex. That's the opinion. It's pretty straightforward. It doesn't leave a lot of room, I don't think, to, in terms of what the opinion means. It's pretty explicit that now we know that sexual orientation and transgender status are classifications that are going to fall under Title VII and under the prohibitions for discrimination on the basis of sex. And again, the court didn't go back to Price Waterhouse here, but I think it easily could have. If you're discriminating against someone who is transsexual and is not acting or identifying in accordance with his or her gender, it's no different than the discrimination that Ann Hopkins endured in the Price Waterhouse opinion, because she was not, in stereotypical terms, acting like a woman should act in the workplace.
Right.
So now that we've kind of gone through that, I want to talk a little bit about the impact, because I know, many of our clients are aware of Bostock. We know what it means. Now it's, what do we do with it? What has the impact been? This opinion came out last June. We've had some time now. And so, there's a lot of unresolved issues, right? Even though the opinion itself is clear. I know, what about religious exemptions? What about restrooms? What about state law? There's a lot of ripple effects from this opinion that are going to be things that remain outstanding that we need to kind of navigate. We know that this past January, President Biden issued an executive order. And he said for all of the federal agencies and all of the federal laws that prohibit sex discrimination, these agencies need to go back, they need to look at their rules, they need to look at their policies, and they need to make sure that it complies with Bostock. This is going to include Title IX and the Department of Education. It's going to touch fair housing. It's going to touch immigration. Diamond, do we know, have any of these agencies gone through a rulemaking process on this yet? I mean, where are we at on what the agencies have done from a federal standpoint?
It's interesting. A lot of agencies, since Biden brought out that executive order, have said that they are going to make decisions that now sex and under Title VII actually includes sexual orientation and gender identity as these kind of protected classes. But I don't think we've really seen any agencies actually start engaging in that formal rulemaking process yet. I did see that for Title IX purposes on June 16th of this year, the Department of Education's office actually issued a notice of interpretation that explained that it would enforce Title IX's prohibitions on discrimination to include those classes of sexual orientation and gender identity when talking about sex.
Right. And so we know this is one of those areas where the rulemaking and the agencies, they issue all this interpretive guidance. Of course, this stuff is not binding, right?
Right.
Could very well say that whatever, the Department of Ed has said when it comes to Title IX is not binding. But I do think that now that we have the Bostock opinion, these agencies have more support or backing than they would in other areas because, for instance, like with Title IX, the language and the prohibition about discrimination on the basis of sex is very similar and to Title VII's language, correct?
Correct.
And so what about the courts? Do we have any opinions yet that have touched on this issue? I know one question that we got from our participants and something that a lot of employers are thinking about, and if anyone has additional questions as we're going through this, I encourage you to put those into the Q&A section and we will be sure to try to get to them. But bathrooms, what are we going to do about this?
Yeah. And that's a question a lot of people have right now. So bathrooms, like we said, Emily just said, they weren't addressed specifically in Bostock, but there are a lot of cases that are kind of coming and making a forefront in case law right now that would be important for employers to be aware of, just because they may be instructive on how a federal court might rule on Title VII issues down the line, because we don't have a lot on the bathroom issue. There's two cases that I can talk about generally that have actually kind of addressed the restroom issue. And there was Grimm v. Gloucester School Board, and there was also Adams v. School Board of Johns County. So both of these actually a transgender male, so they had similar facts, both cases. And in both cases,
Title IX cases, right?
Yes. These are Title IX, strictly Title IX. But in Grimm and Adams, a transgender male wanted to use the boys' restroom at school, but the school denied that and required them to use the bathroom that matched their gender identity, or they just offered them like a unisex bathroom option. In both of these cases, the courts actually held that this was discrimination, like Emily said, under Title IX, not Title VII, but they said that this was discrimination under Title IX, and they relied in the Bostock decision in making these determinations. It's actually interesting to note too, in the Adams case, the initial opinion held that the school bathroom policy violated equal protection rights and violated Title IX. But when the court issued the opinion, one of the judges actually refused to issue the mandate, which is what you bring back to the lower court to issue. But actually one of the judges just sat on it, and the court went back and revised its opinion and just decided the case on equal protection grounds and left Title IX kind of out of it, which is pretty interesting to note. Also, Emily, there was an Illinois case that came out recently this year in August, if you wanted to touch on that one too.
Touch on that. And one more thing going back to these Title IX cases, under Title IX, we have rules that say that you can establish separate, bathrooms, locker rooms, facilities, and these cases really, the schools in those cases tried to rely on that to say, this is weird. What we're doing here is consistent. And really separate facilities is very different from the issue of denying one individual the opportunity to use the facility of their choosing, right? And that's where the discrimination piece comes in under Title IX. And so, similarly, I think when we look at the Title VII context, I'll talk a little bit about this Illinois case. The Illinois case that came out this past August was not decided under Title VII. It was brought under the Illinois Human Rights Act, which is state counterpart to Title VII, as most states have. And in that case, there was a very long-time employee who was a transgender female who wanted to use the women's bathroom. And the store I think it was a Hobby Lobby store, had accommodated this employee in many ways, changed her personnel records to the extent it was able to, and referred to her by her female name and pronouns as she wanted to. But when it came to this issue of the bathroom, the employer kind of put its foot down and said, we're not going to allow this. The employer also went and actually renovated the store to create a single occupant, unisex bathroom. which it offered her the ability to use. But, when you read these cases, this employee suffered serious, complications as a result of this. I mean, serious emotional distress and trauma and even physical issues where she would be, holding it all day, essentially not using the restroom at work. She would walk during her breaks, down to another store to be able to use the restroom. And so, the damages that she had as a result of this were not insignificant by any stretch. And the court determined that the Illinois Human Rights Act actually prohibited this, and that denying her the opportunity to use the restroom of her choosing that was affiliated with her, her sexual orientation, gender identity. See, these terms get really was something that violated the protections under the law. So, what does that mean? Again, this opinion is not binding on anyone outside of the state of Illinois. I'll also note that the Illinois Human Rights Act actually includes sexual orientation as a specific protected characteristic. We don't have that, for instance, here in Tennessee. In fact, we have quite the opposite. Our Tennessee Human Rights Act was amended to specifically state that sex only refers to someone's biological sex as reflected on their birth certificate. We're also the only state that won't allow someone to go back and amend a birth certificate to change, their sex. So I don't think that, I'm not saying that this opinion would be the same necessarily under every type of state anti-discrimination law, but, it's something to, I think, be aware of in the context of bathrooms, because as far as I know, it's the first opinion that looks at this in light of Bostock under, in the employment context, as opposed to the Title IX context. But I'm interested to hear I know some other people would like to hear too more about, how does Bostock impact state law, if at all?
Yeah, so you kind of touched on that too with the Illinois Human Rights Act, but many states do have their own version of Title VII. So for instance, in Tennessee here, we have the Tennessee Human Rights Act, like you mentioned, and that applies to employers with 8 or more employees. So it's interesting to note that there are different laws, and Title VII doesn't preempt these laws, but as an employer, you may be subject to one or both. So in Tennessee, if you have 8 or more and the 15 or more, you might be subject to both Title VII and the Tennessee Human Rights Act. So states often are looking at cases now that interpret Title VII when looking to apply their own laws. And we've actually been monitoring states to see if they're amending their laws in light of the Bostock decision, and looking to see whether they interpret these acts like the Illinois Human Rights Act and the Tennessee Human Rights Act in line with kind of the Title VII and Bostock. But we, as Emily mentioned, in Tennessee, really, we don't define sex in Tennessee as sexual orientation and gender identity, but rather it's what was on that person's birth certificate. So it's based on what you identified with at birth. So other states have different approaches to this too, but we've seen this kind of varying across states with Bostock. And again, the decision is fairly new, so we're going to keep monitoring and seeing what other states apply. But I know in Tennessee too, there was an interesting bathroom signage law that was enacted this year. Emily, if you want to kind of touch on that too.
Right. Yeah, we did. The bathroom signage law was pretty widely criticized within the LGBTQ community as being an anti-trans law, and it required any public or private entity or business that operates a business or facility that is open to the general public to post, that has a formal or informal policy of allowing a member of either biological sex to use any public restroom, to post a kind of obnoxious sign, essentially, that has specific requirements on the size and the font and the color. This law actually was passed and went into effect back on July 1st of 2021, but it was immediately, the enforcement of it was immediately enjoined by one of our federal judges here in the Middle District. And so it's not something that is currently in effect, but I think what we're seeing here is, states reacting to Bostock in a way to try to take, measures to counteract some of what may be required from a federal standpoint, at the state level. And so I anticipate that there will be, more litigation over this and more, certainly this is not going to be the last that we hear about legislation like this bathroom signage law.
Definitely.
So we also know that the bathrooms, the locker rooms, that those are going to be an area that's ripe for litigation, not just for employers, but also for businesses, in the public sector. But what are your thoughts, Diamond, on other areas where we can see some of these claims arising?
I think we might see claims start coming in maybe like the hostile work environment context, specifically when we're talking about these like gender misidentification issues. And I'll talk more about this like when we get to it later. But a lot of times when you're in the workforce, you can't allow employees to continuously, repeatedly, intentionally be referred to as the pronouns that they don't identify with. And if so, that could be creating and ratifying type of like a hostile work environment claim. There was actually a case that came out, Doe v. Triangle Donuts. And as far as I'm aware, it was the first case to show that gender misidentification can be something that could constitute a hostile work environment. So in this case, the transgender female actually alleged that during her employment, customers would constantly ask her about her gender. Employees at the workforce would continuously ask about her gender. They misgendered her frequently, and the employee actually placed her out of view of customers. And the court really looked at this and found that the transgender employee adequately stated a hostile work environment claim. So I think it's really important that we teach employees in training or any kind of issues just how to use pronouns, how to identify people correctly with the pronouns that they identify with. And I think a good rule of thumb is that the correct pronoun is the pronoun that an LGBTQ plus employee uses to refer to themselves. So we need to make sure we're using that correctly. We also might see other claims arising in the dress code context, because we've already seen this kind of addressed by airlines. Airlines are actually getting in trouble now because they have either male-focused uniforms or female-focused uniforms that are actually not being applied uniformly. So we've kind of seen this issue addressed with the airlines already. So I guess when we're doing these dress code policies, we should keep them kind of gender neutral if you're going to have a policy, and not about like hair needs to be this or, jewelry and things like that. So if you're going to have one, it should just be a gender neutral, just to avoid these issues from coming up. And I think that'd be a good business practice. We also might see other claims kind of coming from employee benefit plans. So if you're self-insured and you have things like exclusions for sex reassignment surgery, you might be getting in trouble with that, or just crossing a fuzzy line that hasn't really been addressed much yet. There was a case that I did find, and it was called Georgia Lang v. Houston County, and the plaintiff challenged a provision in an employee's healthcare plan that excluded coverage for sex change surgery. And the court actually found that the argument was precluded by Bostock and held that employer to be liable. So yeah, I think we might see issues with the whole gender misidentification and hostile work environment claims. I think we might see it with dress codes and a little bit with these insurance and benefit plans.
Yeah, I think that the case, the Doe versus Triangle Donuts case, is an interesting one, because one of the issues was not just their employees referring to this transgender female employee by the incorrect pronouns, but also customers.
Right.
A really touchy subject. How do we deal with that as an employer? We know that under Title VII, it doesn't just prohibit, it's not just harassment that is, committed by other employees, but also vendors and customers. That's something we're going to have to deal with as an employer. And in many ways, the, something like moving the employee outside of the customer facing role might have been seen as some type of an accommodation for that employee to kind of prevent that. And yet it also gets used as the basis for the claim. So you really need to think through kind of how can we as an employer be sensitive to these issues? How can we address them? How do we confront them? And I think in a lot of cases that just requires kind of a dialogue with the employee. What is it that they want? What is it that how can we support them? How can we, help, with educating the customers and the employees, about these types of topics and issues. I know that one's a hard, going to be a hard one for us to wrestle with as employers, is when customers are the ones that are, contributing to the hostile work environment in some way.
Right. I agree. And I think a lot of these issues can just be, alleviated by just talking to the employee, like you were saying, just asking what pronouns to identify with, or changing our email signatures, or, just making it inclusive so people can kind of see, like, this is what and mistakes are going to happen, which is fine. So I think it's important just to say, thank you for correcting me and moving on with that.
Yeah, I think you bring up a really good point, Diamond, because this is an area where there's appropriate terminology is just, it seems like this is an ever expanding, we have these things like binary, non-binary,
Right.
transgender, and it's, there's lots of different terms here, and knowing what the appropriate terms are is an area where I think it's easy to get hung up. Do you have any tips for our clients on good resources to go to kind of know what the appropriate terminology is, so that we're not inadvertently offending someone?
Yeah, definitely. There's a lot of resources online. There's two good ones. The Human Rights Campaign actually has a whole glossary of LGBTQ plus terms, so that can be helpful. Also, the Department of Labor issued Employee and Applicant Right Responsibilities Desk Aid, which provides key terminology too. So that can be helpful to kind of review. And like I said earlier, if you have training, kind of getting employees and supervisors and managers up to date and aware of this terminology, so everyone's kind of on the same page. Allowing employees, like I said earlier, to be referred to as the pronouns they don't associate with can be creating that kind of hostile work environment. So I think it's important. Some things that we could do are, don't make assumptions. So don't make assumptions that someone's pronouns, especially in today's day and age. So I know we've seen some companies using email signatures to kind of show, okay, these are your pronouns, like I said earlier. Or when you meet someone, you could say, hello, this is my name, and these are the pronouns I associate with. Or, there's a lot that you can do, but it's important to know, like I said, mistakes will happen, but it's only if mistakes and accidents turn into kind of deliberate, intentional, and repeated use of referring to someone as the wrong name and the wrong pronouns that we could be seen as, ratifying this hostile work environment. So I think part of alleviating that issue is getting everyone up to date on the appropriate terminology. And there's a lot of resources out there that you can review to just make sure everyone's using the same terminology correctly.
Right. At the end of the day, this is still going to be one of those areas where the employee is going to have the obligation to notify the employer in some way. Here's what pronouns are. Here's what, what I'm associating or identifying with. Because again, as you said, gender identity is an internal thing. It's an internal, method of expression of gender. And so we are not going to be obligated as an employer to make an assumption about what that may be. And so I think, but once we are on notice of, the fact that someone says, I would like these pronouns, or I am being, someone says they're going to, they identify with feminine pronouns, and yet the coworkers continue to refer to them with male pronouns or a male name that they may have gone by in the past. Yeah. That's when we're crossing the line.
Exactly.
The employer, we need to step in and take some type of action. So, and I think another big area here in terms of best practices, what do we do as employers, is going to be training. This is probably not something that we have included in our harassment and non-discrimination training in the past for many of us. So we're going to really need to make sure that our supervisors and our managers know that this is a form of prohibited discrimination. So not only is it good to be focusing on, inclusivity training now, which would encompass these types of topics, as opposed to just the harassment and non-discrimination training, we really need to make sure that our management is aware of the fact that this is something that if you are an employer that is covered by Title VII, needs to be dealt with the same way we would deal with a sexual harassment claim. If you have an employee who comes to you and makes this type of a report, they need to know to refer that to HR or an appropriate representative so that we can investigate and take prompt and effective remedial action to end the harassment, because that's where the claims will arise. And if people don't know that this is something that is actionable, then they are not going to know to necessarily report it, which can result in liability on the part of the company. So it's really imperative to train our supervisors on these issues, LGBTQ rights, specifically eliminating implicit biases is another topic of training that I think, any employer should be considering. The misgendering, referring to someone by the incorrect pronouns that are not consistent with what they have expressed, they would like their pronouns to be. Facility usage as well is going to be something that we need to talk, to employees about. So I think that is going to be so critical here to maintaining compliance, especially as people are returning to the office. Most people, when this decision came out, weren't in the office environment. And so many of our clients may have not done the type of annual training that they would have normally done, or certainly not in the format that they would have done it in. So, I think that's something, to think about, as people are coming back, this needs to be incorporated. We're going to talk about handbooks, next, but certainly taking a look at these handbooks and updating those. Diamond, what are your thoughts on that? And just in terms of policies, what do clients need to be aware of there?
I think that it's great business practice to go ahead and try and change these policies to gender neutral terms in handbooks. LGBTQ discrimination can arise when terms aren't neutral in your handbooks and your policies, and you're making distinctions that really discriminate against LGBTQ plus employees. So I think that it'd be great to use maybe first person you instead of he and she or they, words like this, so you're not kind of making assumptions on people's pronouns, or instead of husband and wife, maybe using spouse, terms that kind of are just gender neutral and that you can't offend someone. And I also think I talked about this earlier, but you could update your job descriptions and dress code policies just to make sure they're gender neutral, and you avoid that male and female specific dress code and consider those non-gendered options. I think it's also good business practice to go ahead and review those job applications and HR forms and just make sure there aren't check boxes that are leaving out certain relationships or identities, or maybe a write-in option for people who don't identify as male or female, or whether they have a different name than their legal name. It's just good to go ahead and make these changes right now and follow these good business practices to avoid any chance of liability coming up in the future.
Right. And I think, I think we got to, as with any type of big change like this, it can very easily feel overwhelming.
Right.
You're not going to be held liable if you use he and she in your employee handbook right now. That is not going to be in and of itself a basis for liability. Where liability can arise is when you have policies that that you're making distinctions about that may discriminate on and against someone who is an LGBTQ. The dress code is a great example of that, Diamond. But I do think that generally speaking, we do this a lot just with the practice of law, using defined terms, employee, referring to someone like an employee. You is a great way to kind of get around the he, she, their, concern. And, just as you go through and update your policies, think about making some of those changes. I also really love your comment, Diamond, about having a place on a job application for someone to list their preferred name. We know as an employer, for instance, for tax reporting purposes and things, we have to go by the employee's legal name. And, in some instances, that may not be consistent with the name that they are going by. And there's a variety of reasons for that. It may not even be a gender issue. It may just be what someone's preference is. And so having that type of a space and then using that name is a great way to kind of be able to address this from an HR onboarding standpoint, and kind of alleviate that. A lot of people have asked me, do we need to add pronouns to our signature blocks? I know you mentioned that earlier, Diamond. I think that really depends on your company. It depends on your business. It depends on your culture. It depends on your customers and who you're engaging with as to whether or not that is something that is a decision that you feel like you need to do. at this point, don't think that it's something you have to do. I think it's a choice. I think it promotes inclusivity and fosters that environment, but it's also at the end of the day going to depend on what's right for you, for your size business, and as to whether or not that's something that you think would be a good business practice. So Diamond, do you have other thoughts on, as we're talking about kind of best practices here, that you feel like would be good to share? And if anyone has any questions, I would encourage you to, put those in our question box so we can be sure that we get to those.
I think you said most of it. I think it's great to go ahead and think about these issues now, but once again, it's not a one size fits all approach. It's very company by company based. So if this looks like it fits your company, that's great. And also just to keep up with the changing laws, because this is fairly new. So this is always changing across state spans, and just to be able to just know that, be aware that this is happening right now, and just be aware that these are actually sexual orientation and gender identity are now protected classes under Title VII, and just moving forward and implementing these good business practices will be helpful, I think.
Awesome. Well, I really appreciate everyone taking the time to join us today. We really enjoyed being here with you, again, talking about something that isn't COVID. And so we thank you for your time, and we hope that you will join us next month for our next Burr Morning Show.
Thank you, everyone.